My name is Maria Casablanca. My nickname is Marissa, and I've been practicing immigration law for 35 years. I am of counsel to a nationally recognized immigration firm. Because of the expertise in this firm, we're able to provide excellent services in all areas of immigration law and litigation. The traditional way that most people usually receive a green card when they're here as a professional is they go to the school, the student visa, they graduate, their employer does an H-1B visa petition for them, and then while they're in that status, they can apply for permanent residency if the company wants to petition for them. That category can be an EB-2 if you're professional, have a degree such as a legal degree or a medical degree or some other type of postgraduate degree, and EB-3 is if you're not using that degree for the position. Now, it's always taken about 1.5 to 2 years to obtain the residency through what's called labor certification when the company petitions for you under EB-2 and EB-3. But lately, because of something called visa priority dates, the length to that has been extended a lot. So it's now taking up to 4 or 5 years to actually get the green card. The difficulty with that is that you have to maintain your other status here while you're waiting for that. And what's happened with the H-1B visa lately is that usually only 1/3 or 40% actually make the lottery in order to apply for that H-1B visa. So it takes too long. It's better to do an EB-5 because you don't have to wait for a visa priority date if you come from most countries. The Visa Bulletin is a publication that comes out the 15th of every month that covers what visas or green cards are allowed to issue the following month. So what's happened with EB-2 and EB-3, as I was mentioning, that has delayed the process for the green card for these individuals. Even the EB-2 National Interest Waiver, which was very, very popular a few years ago, it's where you show that you have a postgraduate degree or you have a bachelor's plus 10 years of experience and you are an outstanding individual in your field, then you could apply for a national interest waiver, demonstrating that you are actually a person who the United States would like in the US, basically. So we'd have to show how you are of national interest. Used to be that you could file it concurrently because the backlog did not occur. But now you have to wait again under the EB-2 category, which is several years, in order to apply for the residency because of the visa priority backlog. The main reason is that Congress can only give a certain amount of immigrant visas a year, and unfortunately, the demand is much higher than the quotas, and that's what's happening lately. The implications are that individuals, as I mentioned, have to maintain status in the United States in order to stay here waiting for that permanent residency. And many of them are not able to have an under status. So some students have to actually enroll again and keep enrolling in school in order to stay in status while they wait for that permanent residency to become current. The implications to the individuals are that they have to keep waiting. They can't travel freely, they can't work freely, they're always in a tenuous position, especially with all the laws and the administration changing lately. It's much better to be in a position to apply for permanent residency than maintain a status such as a constant student status, other types of status, because you've applied for a category like EB-2, EB-3 that's taking so long. And you cannot apply for a work permit and travel permit in those categories right away. You have to wait for the priority date. Rather than if you do EB-5, you can apply for the work permit and travel permit concurrently ever since they changed the law in 2022. our immigration laws do have an advantage in that you can apply for several categories. Just because you apply for EB-2 or EB-3 doesn't mean you have to wait for an EB-2 or EB-3 green card. So if someone is able to do it and has the funds and they're waiting for an EB-2, EB-3, it's advisable that they still apply for an EB-5 so they don't have to wait all those years for the green card and they can get the work permit and travel permit sooner. The EB-5 program, we call it the baby program of immigration. Why? Because it's the newest law that came out with immigration back in the 90s. Basically, Congress decided that they want to create jobs in the United States. So what they did is they implemented this EB-5 program, and it's 5 because, as I was mentioning, there's EB-2, EB-3, EB-4s, religious workers, and EB-5. So even though it's an employment creation green card, there's still an investment component. What happens is you file that petition and you file your application for residency, work permit, and travel permit. It's similar as when you marry a U.S. citizen because there's a petition that the U.S. citizen signed and there's an application for the green card with a work permit and travel permit that the applicant files. In this situation, both are done by the individual getting the green card, and what happens is that you will get the work permit and travel permit concurrently instead of having to wait under another category. It also includes spouse and children under 21 years old. What's become very popular lately, because many international students, they want to stay here and their parents have invested all this money in their education in the United States, is parents are gifting the money to their son or daughter who's over 21 in order for them to apply for the EB-5 program. Concurrent filing is very important because it's very few categories you can do concurrent filing. One of them is the immediate relatives of a U.S. citizen. The other ones is EB-5 at this moment, and EB-1. EB-1 is your multinational managers and executives, people of extraordinary ability, that category of individuals. But the majority of us are not that EB-1 level. So EB-5 now allows, since 2022, to be able to file concurrently the petition with the application for the green card. Extremely advantageous because that way you can obtain a work permit and a travel permit very quickly. There is a very big advantage to concurrent filing because many individuals have a visa that they may not be able to sustain. So if you have a petition and you file your adjustment of status with the application for work permit and travel permit concurrently, then you're able to stay here waiting for that work permit, waiting for that travel permit, and your situation may be remedied if your status under student is expiring, under another type of status is expiring. At least you're here in the United States waiting for an adjustment of status and are not an individual who would be a target of removal right away. Now, just to stress, if you let your visa expire, remember, you will no longer be in status. So always consult with an immigration attorney before you take that step. In order for a person to qualify for concurrent filing, they have to be in status, which means they have to be under a student status, they can be under another work visa status, but they have to be maintaining whatever non-immigrant visa status they have. If they have not, then the law does allow something called 245K, that if you have been out of status for less than 180 days, you can file an EB-5 petition, even though you've been out of status for 180 days. It is very advantageous to keep as many petitions pending as possible. If your employer has done an EB-2 or EB-3 for you, and that category is backed up, like for certain nationalities, like Indians and Chinese, if that's very backed up, yes, it is a good idea to do an EB-5 because you can use an old priority date for a new petition. So it's very advisable, consult an immigration attorney because it's a good idea to do another petition if you're able to. In our experience, for our clients, when we filed the petition with the application for permanent residence, advanced parole, which is a travel permit, and employment authorization document, which is the work permit, we have been getting the work permits approved within 3 months. This has been something that's been going on since last year, but of course, no one can guarantee when you're going to get the work permit, but that has been our experience. My suggestion, if you see your priority date lagging because it's gotten longer and longer the past couple of years, is to find a way to file concurrently your application for residence and the petition and not have to wait for priority date. As I mentioned, there's only very few options to do that. There's the EB-1, extraordinary ability, multinational managers, those type of individuals, which is not the majority of the people in the world. There is immediate relatives of U.S. citizens, which is the spouse, parent, or child under 21 of a U.S. citizen. And then there is the EB-5. So there's very few options for individuals to obtain residency and file concurrent filing, which means that the more EB-2 and EB-3 gets backlogged, the more people are going to apply for EB-5. And if you wait too long, then EB-5 may get backlogged too. You never know. So it's always advisable to look into what you need, what your qualifications are, to see how you can change how you are obtaining your permanent residency, even if it's under midstream of another category.